This series of videos will provide information about the considerations that tenants in Massachusetts may want to think about before they move into an apartment. There are four main types of tenancies in Massachusetts. Tenants with written leases. These are tenants with a written agreement that states the agreed upon rent and the length of the tenancy. Tenants at will. These are tenants with month-to-month tenancies, which may be either written or oral. Either party can end the tenancy with a rental period notice. Tenants at sufferance. These tenants are those who stay in an apartment after the tenancy has ended and without the permission of the landlord. Tenants by regulation. This category includes tenants of public or subsidized housing who have additional tenant protections beyond what is described in these videos. It's important to note that in subsidized tenancies, the lease is very important, but there are also statutes and regulations that impact both the landlord and the tenant's rights and responsibilities. If you are reviewing a lease, here are some tips. Read the lease carefully. Don't let the landlord rush or intimidate you into signing anything you don't agree with or understand. Both parties must sign the lease, and you should receive a copy within 30 days of signing it. There are some key terms that must be in the lease, like the amount of the rent, the date on which your tenancy ends, and the amount of your security deposit if you are paying one. All of your rights concerning the security deposit should be listed in the lease. The names, addresses, and phone numbers of your landlord and any other person responsible for maintaining the property and the person authorized to receive notices and court papers should be listed in the lease. Regarding tenancies at will, if you are living in your apartment without a lease, but you do have permission of the landlord, you are a tenant at will. It's the most common type of tenancy in Massachusetts. It's also referred to sometimes as a month-to-month tenancy. Sometimes these tenancies are in writing, and sometimes they're a verbal agreement. The landlord may only raise the rent by giving either 30 days or one rental period written notice, whichever is longer. A tenant or a landlord may terminate the agreement by giving 30 days or one rental period, whichever is longer, written notice for any reason or no reason, as long as the underlying reason is not discriminatory or retaliatory, and we'll talk more about that later in these videos.